Consider the following case involving Ripple and the SEC. The ongoing legal conflict between Ripple Labs and the United States Securities and Exchange Commission (SEC) and XRP decisions has resulted in the issuance of a new scheduling order by Judge Netburn, which takes the XRP case forward. Despite the fact that Judge Netburn was recently appointed to the position of judge in the Southern District of New York, her participation in the Ripple SEC case has not been altered. She has continued to preside over it, and she has garnered a reputation in the world of Bitcoin for making rulings that are balanced and impartial. In order for the SEC to submit their opposition to Ripple's request following this nomination, they were given until April 29, 2024. A response to the request will be sent by Ripple within a period of 3 business days after this. Ripple and the Securities and Exchange Commission (SEC) are engaged in a court war that is still going strong and is becoming more intense than it has ever been. Ripple has become a significant player in the realm of law as a result of the nomination of Sarah Netburn to the position of District Judge for the Southern District of New York's Dan Department. Netburn is currently in charge of overseeing the case between the SEC and Ripple, and it is possible that Ripple may prevail in the lawsuit. It is possible that her advocacy for cryptocurrencies and her reputation for making choices that are fair will be the decisive factors in relation to this significant appointment. The announcement of Netburn's nomination comes at a very crucial moment. As a result of the ongoing conflict between Ripple and the Securities and Exchange Commission (SEC), as well as Ripple's vehement objection to the SEC's imposition of significant fines, her role as a judge has significantly increased in significance. Ripple has entered a lawsuit against the SEC's absurd demands, and the company has made a good argument against them. In addition, it has proposed a scheme that would impose a maximum penalty of $10 million. Ripple appears to be in a favorable position as a result of the fact that it has presented 3 compelling arguments that deny the claims brought by the SEC and highlight modifications to the manner in which XRP is sold. Go for it. A Ripple, it is possible that they will be able to benefit greatly from the anticipated ruling of the court, particularly if it is carried out with Judge Sarah Netburn providing oversight. But if Netburn makes the decision to back Ripple, the Securities and Exchange Commission (SEC) would face a lot of challenges that will make it difficult for them to reverse their thoughts. Ideas from legal professionals. There were a few individuals working in the legal area who were overjoyed when Netburn was nominated. In reference to the litigation surrounding Bitcoin, Paul Grall, the chief legal officer of Coinbase, lauded her and stated that she possessed a great deal of knowledge on the legal difficulties that are associated with cryptocurrency. When it comes to the importance of having skilled judges, Gerald emphasized both. Sarah Netburn, who is now serving as a United States magistrate judge in the Southern District of New York, deserves congratulations on her upcoming appointment. In addition to teaching crypto and other individuals about the significance of having excellent judges in the judicial system, she has been nominated to become a United States District Judge on the same court. In addition, Netburn's nomination was lauded by Bill Morgan, who is a well-known advocate for extra coin. According to him, the reasons for her acclaim include the fact that she made decisions that were fair and handled the SEC Ripple case with ability. Through his support, Morgan draws attention to the net. The fact that Byrne is known for being a judge who is both impartial and skilled demonstrates that her nomination as a district judge is well-deserved and has the potential to assist Ripple in her legal proceeding. Additionally, the fact that Morgan is on their side demonstrates that their relationship is doing well for the time being. Specifically, Ripple requests that the company's expert papers not be taken into consideration in the remedy case. This request is made in a letter that is addressed to Magistrate Judge Sarah Netburn. It was reported by Ripple that these significant documents were discovered. According to these files, the Securities and Exchange Commission was unable to provide an additional expert opinion on the subject of disgorgement. In addition to this, they display a significant remark that was made by Andrea Fox, who is an assistant chief accountant for the SEC, as a result of the absence of information. It has been reported by Ripple that they were not given the opportunity to effectively defend against the issues made by the SEC. Additionally, Ripple criticizes the SEC for classifying Fox as a simple summary witness, stating that her analysis makes her an expert whose thoughts should have been provided earlier. As a result of the SEC's refusal to permit Ripple to be excluded from the process, the schedule for the subsequent sessions has been established. Ripple's motion has the potential to have a significant impact, potentially altering the SEC's perspective on remedies and the outcome of this high-stakes case, which would have repercussions for the whole cryptocurrency industry. The decision that is reached in this case may have repercussions for the entire Bitcoin technology sector. As of the 6th of May, the Securities and Exchange Commission is scheduled to submit its reply brief, and third parties have until the 20th of May to object to the sealing. Although there are valid points, only time will tell whether or not Ripple's petition to reject the fresh expert opinions made by the SEC, which are intended to bolster the SEC's case for remedies, will be granted. Due to the fact that it answers the motion, this order addresses a final judgment, which is a very important decision. Ripple maintains its unwavering conviction that the Securities and Exchange Commission is exceeding the bounds of what the law permits. A look at the most recent perspectives of the dispute between Ripple and the SEC. Ripple contended that a settlement of $10 million would be better than the $2 billion that the SEC had demanded for in civil penalties. Nevertheless, Ripple asserts that the allegations brought up by the SEC are excessively high and do not have sufficient proof to back them up. Ripple has also argued against the justifications that the SEC has given for prohibiting people from functioning in the cryptocurrency industry. The company has stated that there is no relevant proof of financial. It is the purpose of this case to demonstrate that there is no evidence to suggest that the company's substantial XRP sales have been subject to any potential infractions or irresponsible behavior in the future. Any projections of discouragement, according to Ripple's point of view, ought to take into account what a reasonable entrepreneur would anticipate. One of the most important aspects of the company's case has been its defense, which asserts that Ripple's on-demand liquidity OS sales are not investment contracts, contrary to what the Securities and Exchange Commission has stated. Customers are only need to hold on to XRP for a brief period of time in order to facilitate the easy transfer of funds across international borders. Rather than using ODL for investment purposes, it appears that the majority of people use it for commercial purposes. XRP was not designed to be used as a commodity for investment purposes, which is the primary point that Ripple is trying to make in their argument. With the argument that this is the most significant point, it is possible to demonstrate that the glamorous designation of XRP as a security is not accurate. Ripple has stated once more that the Securities and Exchange Commission has not demonstrated that there is a high likelihood of future violations, which is relevant in the event that the SEC intends to punish the business with significant penalties and other sanctions for irresponsible behavior. The content of this page is not intended to serve as trading advice, and we do not take any responsibility for any investments that are made on the basis of the information shown here. Before making any decisions regarding investments, you should conduct your own study and consult with an expert who is knowledgeable in the area in which you are interested.